Hey everybody, Nancy Cogar here and welcome to Boomer Time. We are talking about how to stay out of court. Important topic, and I'm calling it my Elder Law Essentials. So I'm going to go through some things that are elemental, but they'll be important to you because I truly believe if you had any of these, it will help you to stay out of court. Save you time, money, frustration, all of it. That's important, isn't it? So the first one is put a power of attorney in position. I touch on this in many of my past episodes, but I wanted to emphasize this as an important aspect and reason for seeing an elder law attorney like me for estate planning needs. Trust me when I say that you need the right kind of powers of attorney and end-of-life directives in place. You do not want to cut corners when it comes to these issues. There have been no shortage of legal battles over these types of issues. Absolutely know that the hospital, the ER, the doctor's offices, nursing home, or whoever may be treating you or overseeing your welfare during an emergency health situation is going to want more and should, because having such an authority in place protects you and them, doesn't it? Right? And think about this. You don't want that other person that you do not trust stepping in and making the decisions for you, do you? I know you don't. I wouldn't. And I don't think you would either. So the importance of powers of attorney and end-of-life directives. Here's why they're important, okay? Directives prevent legal battles during emergency health situations, especially end-of-life circumstances where machines may be keeping you alive artificially. You need to have directives as to what you want in that circumstance. So powers of attorney give healthcare providers the necessary authority to act. These are the people that you appoint, okay? They protect both you as the patient and the healthcare providers because the default is just to provide life-saving measures until it's not possible anymore. So if you want something other than that, you are going to have an end-of-life directive that specifically articulates that. So it also ensures that not only trusted individuals of yours make decisions on your behalf. I'll tell you the truth that when I do these types of documents, I have many, many people who want to put preclusions in the documents. What that means is there are certain people they don't want making these decisions in any circumstance. Okay? That's important. Think about that. So you also want to have a solid beneficiary plan in place. What do I mean by that? Well, here's something that you might not initially think about, okay? But it's an important aspect of planning for an elder law attorney like me. Not just in terms of future disposition of your property, but as to how it's held now and what, if anything, can be done to better utilize those funds for you in your older years. You know, we also talk about strategies that may keep that property completely out of court when you do pass. That is super important. When you schedule a strategy session with me, we look at your assets, okay? Different kinds of assets pass different ways. That is important as well because one kind of strategy may not be enough. You may need several different strategies incorporated into one estate plan. I have routinely had conversations with my clients' financial advisors as part of the planning process. This is just a normal step. So we confirm how things are held, how the client believes that they will pass, including any beneficiary designations and contingent or secondary beneficiary designations, and we confirm those. If they're not there, we make sure it says what you think it should say. So those are all in place, and then we look at strategies to allow for a low cost, easy transition after your death that will not require court assistance. That's part of what I'm doing through this planning. So I'm saving you money on the long run, and you're making an initial investment that's worth it. So let's recap about beneficiary designations and how important they are to consider for asset distribution upon your death. You want to consult with a financial advisor to understand how the assets are held and how they may pass after you die. You want to make sure those beneficiary designations are in place and then correct them if they're not, and then implement contingent or secondary beneficiary designations to ensure the assets are distributed as you intend. Okay? So we want to use strategies to allow for a smooth transition after your death without requiring, again, court involvement. It's slow, it's expensive, it's cumbersome, and it's stressful. You want to avoid that. I'll be right back with more in a minute. Welcome back. I always feel that we can learn from other people's experiences, even if they're difficult. So for that reason, I want to share a story with you, and it relates to capacity or losing your capacity. So if you don't choose to do things, there are consequences for that. And I'm reminded of a story recently involving a case where there was an older woman living in her own home. She was in her late 80s, and she had some capacity issues. She had no family in the area, so there was no one that really took note of that. She didn't have any estate planning in place either. So when she came into our world, it was really unbelievable. We had people in the neighborhood who were helping themselves to her property inside the house, even her food in the freezer. They'd move in and out. They had the alarm code to the house, and they all said they were just trying to help. Well, nothing could be further from the truth. And now this woman is getting some help, but she wasn't able to make decisions because she lost her capacity. So it made things even more complicated and made it complicated so that it had to be done in court. Remember, we talked about staying out of court. So I want you to understand the issues that come with capacity, because capacity issues are a huge issue for obvious reasons, just like the story I told you. Some of my clients come in looking for estate planning and long-term care assistance, and that's following a health diagnosis that will eventually lead to their incapacity, right? That's not easy. You want to have the right analysis and the right documents in place to protect both your assets and you, okay? Those who you put in charge if you're not able to make decisions on your own. You don't want neighbors moving in and out of your house, helping themselves to your stuff. Capacity is just one of those issues that comes up often in will contests. Someone contests your will. It happens all the time. And that leads to litigation. There's an accusation that Mama wasn't in her right mind when she made her will, and Maybe Sister Susie drove Mama to the bank, right? And made her sign the document, which, surprise, surprise, benefits only Susie. Any of these issues can lead to a will contest and really lead to the potential of that will becoming invalid after a long and expensive lawsuit. That is the last thing you want, and I work hard to avoid and protect you from those things. When I have individuals with these types of issues, there are specific things I do proactively to confirm someone's capacity and protect any documents from a future contest, whether that's powers of attorney or wills or trusts. Capacity issues are huge. So I hope you understand how important capacity is. So now I want to do a recap on some of the things we talked about related to capacity. Capacity concerns are a major one in estate planning, especially for clients with those health diagnoses that will eventually lead to incapacity. Okay, proper analysis and documentation are crucial to protect the individuals and their assets, and to designate decision makers in the case of future incapacity. Capacity is often the root in disputed will contests with accusations including undue influence or lack of mental capacity. These issues can invalidate wills and other legal documents. That can all be prevented with proactive measures to confirm your capacity and protect the documents from future contests. Next, I want to talk about considerations concerning conservatorships. So an elder law attorney can and should talk through possible issues that may lead to a court-ordered or directed conservatorship in the future. You don't want this to happen. It's expensive, always stressful, and essentially, it's a last resort option to step in and try to help an aging loved one who has some level of disability. Could be physical, could be mental incapacity. But they didn't take the time to put powers of attorney and other documents in place, which would have avoided such a conservator action, and authorized those loved ones or another as a fiduciary with the loved one's best interest in mind. So as I mentioned early on, there are consequences for decisions and for not making decisions, right? Well, this one is the one that I think the most about, the consequences of not making decisions. Sometimes conservatorships are helpful in managing someone's care, well-being, and personal affairs over a long period of time. For example, if they're disabled and say they turn over 18, that's when you have to have a conservatorship in place. But if you don't take the time to do estate planning, there's really no option. So let's do a recap on conservatorships. An elder law attorney should discuss possible issues with you that might lead to a court-ordered or directed conservatorship in the future. Conservatorships are expensive. There are 3 lawyers involved in each action, and even more potentially. It's also stressful. It's a last resort option for aging loved ones with disabilities or incapacity. These are folks who didn't put powers of attorney and other documents in place when they could. As I've said, consequences exist for both making and not making decisions. And there's always an exception to the rule, so sometimes conservatorships are helpful in managing someone's care, well-being, and personal affairs over a long period. especially if they don't have family or if they're disabled and over 18 years of age. We're going to take another quick break, and when we come back, I've got more issues that you need to know about and also need to know how to navigate them to avoid going to court. I'll be right back. Welcome back to Boomer Time. We are talking steps to take to keep yourself out of court, and your family for that matter. So one thing that I want to make sure to mention is that you need to talk to a professional about your plan. Whether it's your estate plan, your long-term care plan, your end-of-life plan. You need to have a detailed and specific conversation, just like my strategy sessions. That's why I do that as part of your estate plan. This should be the first step, okay? And even if you're just updating, because as you know, the issues that may have been your concern 20 years ago aren't necessarily the same issues you're concerned about now. The kids are grown, you live in a different state, the circumstances are different. You need an experienced attorney who will navigate through those issues as they relate to your estate plan and your assets, your property. This includes, but is not limited to, any need for things like special needs trusts, Medicare, VA benefits that may be available, possible spend downs that may need to be calculated now, right, before you apply for any future assistance with nursing home care, and maybe strategies to avoid nursing homes altogether. I work a lot through those, and it's my priority to keep you at home. And most people have the same priority, but you have to have a plan in place in order to make that happen. There are lots of other issues that come up under the umbrella of long-term care planning and end-of-life care, right? Everything from paying for renovations to your home to make it more accessible, to caregiving, to asset property protection, and aging in place. That's a fancy way to say keeping you at home if possible. You know, the average cost of nursing home care is upwards of $100,000 each year, and it's just going up. So you need someone who can evaluate your estate plan from the perspective and awareness of potential not only long-term care costs, but also tax consequences. What's taxed and what's not taxed? Do you have any exemptions that are available to you or amounts you can escape from taxation, right? How do you do that? What else do you need to be aware of? How does the state of Tennessee handle inheritance tax issues? Important stuff. What happens if you sell your parents' home and you receive a 1099 in the mail? What do you do with that? What happens if you decide to quit claim the house to get it out of your parents' name? You get the picture, right? These are such important topics. So I want to recap again that these are ways to stay out of court, right? My elder law essentials. So first one, put a power of attorney in position that articulates what you want and who you want to do it. Also can include who you don't want to do it, right? And make sure that document allows that person, that fiduciary, to do the things that will be needed when you can't do them yourself. Also, second, have a solid beneficiary plan in place. You would not believe how many people come to me and thought that there was a beneficiary on something and it never got updated. And guess what? If there is no beneficiary, the estate is the beneficiary. And guess what? That means you got to go to court. Remember to put a solid beneficiary plan in place. Capacity concerns. Talk to a professional about those and how they relate to your plan, both when it comes to availability of your own monies to help you maintain your quality of life and to plan for others to help you. And stay at home, right? I hope this has rang true with you and you're taking away some good nuggets today. This is important stuff. So another reminder, all right, if you like the show, Boomer Time, you don't want to miss out on any of the great information and resources that we offer here. That is important to me to bring you those. You want to follow and subscribe, okay? Follow Boomer Time, subscribe. It's on YouTube, Spotify, and then also follow us on Facebook, LinkedIn. Right? You want to reach me? Then all you got to do is go to my website, nancycogar.com, and go to my contact area. You can schedule a strategy session. You can let me know what you think of the podcast. You can send me questions. Maybe it'll be part of a future show. I'm here to help. So that wraps up our time today. And I really feel like these things are so critical. Basic things, but things I see over and over again. I hope they're helpful to you. So thanks for listening and watching. And we'll see you again next time on Boomer Time.